Right now in Chicago, a judge is hearing arguments over an order that blocks the National Guard from deployment in Illinois. That order expires tomorrow. CBS News legal reporter Katrina Kaufman has more on the legal process playing out. So Katrina, explain exactly what's happening in court today.
So essentially, the judge is going to make a determination about whether she's going to extend a block that prevents the Trump administration from deploying the National Guard into Chicago, Vlad. And it's very likely she's going to do so, especially because both sides submitted a joint status report yesterday where even the Trump administration agreed to potentially allowing a 30-day extension here.
So why is the Trump administration not pushing back on the block this time around? They've done so in the past.
Absolutely, they have. But a big part of it, Vlad, is that they have appealed to the Supreme Court here. They're expecting a decision imminently. And so what they say is that they're willing to wait for the Supreme Court to weigh in. They're willing to give this 30-day extension because they don't think anything more should be happening with these proceedings in the meantime. They say this will allow the district court proceedings to happen in an orderly way. It will give the Supreme Court time to review this. They don't think there needs to be any more discovery or briefing here. And they think whatever the Supreme Court decides will be pivotal.
And so how do you expect this could play out in the Supreme Court?
I mean, that is a great question, but we do know it will have sweeping implications, Vlad. We've seen the administration trying to send the National Guard into cities across the United States. What the Trump administration is arguing here is that the president essentially has unreviewable discretion to determine when to federalize the National Guard, and that even if the courts have limited review in this situation, they say that federal officers are not able to execute the laws properly. And this is a little niche, but a seminal case here is actually from the 19th century. It is this case involving someone who was called up to the New York militia and refused to go. He was ultimately court-martialed. They took away his mare as payment for a fine, and he sued to get it back. He said that President James Madison at the time didn't actually have the authority to call up the militia under this law, which was a precursor to the one that President Trump is using now. The Supreme Court in that case decided that the president did have the authority to exercise that power. And what President Trump's Solicitor General, John Sauer, is saying is that that precedent shows that Trump has that authority here. Now, there are some important distinctions. This was someone who was in the militia. In this case, we're seeing the states challenging this, and also it's about whether the courts can review his decision. And we were also at war at that time, but it will play an important role in what the Supreme Court decides.
Yeah, indeed. All right, Katrina Kaufman for us. Thank you very much, Katrina, as always. Appreciate you.